This matter is on today because Ms. Mathis was cited to court for community control sanction violation. Ms. Mallory, have you received a copy of the report?
I have her reviewed Ms. Mathis. This kind of like a probable cause. She's going to commit rule violation.
All right, thank you very much. Ms. Mathis, is that what you want to do today? Is that what you want to do today? All right. I hear statement of facts.
Control on October 17, 2022 for a period of 5 years. Defendant violated Rule 1, and then on April 16, 2024, the defendant was given a ticket for directing their FRA suspension. The defendant was told on several occasions to be recited and go to court. She was recited at one time, but did not appear for the recite. On the day the defendant was cited, she was still had this habeas. The defendant also violated Rule 8, and she failed to report on several occasions. Most recently, October 9, 2024, a letter was sent for her to report on October 15, 2024, in which she did. The defendant also violated Rule 11, and that the defendant has paid $175 toward her restitution debts. Her payments are as follows. 11/22 to 9/23, $0. 10/23, $50. 11/12 to 2/24, $0. And then on 3/24, she paid $300 and 90 cents.
All right, thank you very much. Anything on those facts, counsel?
Nothing on those facts.
All right. Ms. Mathis, did you hear what the prosecutor said you did to violate your community control? Is it true? All right. What is your plea to the community control sanction violation? What's your plea? All right. It's a plea of guilty that would be accepted and a finding of guilt made. Ms. Mallory, looks like it's on behalf of Ms. Mathis.
Your Honor, since she's been cited, she has made 3 payments. The issue, as she explained to me, is that she's working with GCB to get disability, and they were instructing her not to work. So she was not working. However, it's been denied, I think, twice now. I think now she's under medical review for that. So she is working, and that's what allowed her to make these 3 payments in the last month here.
How much of the payments did she make?
The record reflects something different that she believes she paid, so I don't know if some of the fees went towards credit card fees or towards probation fees. I'm not really sure. The Ms. Harmeyer's record indicates she paid $105,265. She indicates she's paid $700 something.
She has paid a total of $745, but she's calculating what she paid before she was cited and after, right? Did you have a total of $745?
After I get started in court, I just made a total of 3 payments. After you just told me I had a court date. I had made a payment of $260, and made another payment of $270, and then there was another payment of $175. Yeah, but I don't know how that paper is different.
Do you have receipts? Do you have copies of your receipts?
I did, but I did have it, but I left it.
Okay. You do have proof?
Yes, I do have proof. I just asked her, can I go over there and grab the paper before I start court, and she told me to just take it.
Yeah.
Because I didn't know if she was gonna bring what paper she had.
Well, she's probation.
Yeah,
So whatever.
I was a payment thing to get the printout. I've been making payments, and I also have money on me right now. I've been making payments. I got my check stubs ready and everything. I just made 3 payments right after court.
Since the last court?
Since the last court, I made 3 payments.
She was supposed to be there the day of the election day, but she got the court date wrong. So she's since the 11th.
So this month?
Yes.
She made 3 payments this month.
That's what she said, yes. She, probation reflects 2, she says 3.
Your Honor, I printed this out right before I came here today.
I'm sorry?
I printed this out right before I came here today, and also when she was cited, I specifically told her that she had to keep her receipts to bring to court. I mean, I can call over there and double check, but I just printed this out.
Okay.
I know check stubs due.
Ma'am, who are you behind?
I'm Doctoria's mom. When she left, they actually called my phone to speak with her, and they said something about the money that she paid put towards the restitution. I don't know what that means, but that's what they said. And this was just what?
Well, that's where it's supposed to go.
It went to my misdemeanor charge, when I went down there and paid it, it went to my misdemeanor charge, so she fixed it and put it on the restitution. I was called, so.
I'm wondering if I might told the wrong case, when she made the bid.
Okay, I don't know. So that's not the only issue though, is the restitution payments. We get driving on suspension
Yeah.
and failing to report. Yes, what do you want to say?
I was the one that was in the building and had hit me, and I didn't have a license, but it's my car. And I know I was trying to have a license, but I went to court, I had to be cited for court, and they threw it out, but I was driving.
So after you said, I know I'm not supposed to be driving,
Yeah.
but I didn't hear anything after
I
that.
haven't
But
drove after that, and I just went to court, so, and I've been doing.
do you understand what I'm saying to you?
didn't-
I know I'm not supposed to be driving, but everything after that but, I don't hear. Because I know I'm not supposed to be driving. Do you understand what I'm saying to you? All right. And she failed to report on several occasions, but the most recent was last month, right? Okay. Tell me about that.
And for this, and she just recently told me that, and we did on top of the phone, and all that was down there. I will have to.
All right.
I had missed her call, and she called.
All right. State.
And Mary, I will be referring to probation's recommendation.
Is it still the same? Okay. Nan, what would you like to say on probation?
Yeah, my concern is that I just feel like she's not taking probation very seriously for her office visits. She doesn't come when she's supposed to. I've had to send letters, I've had to call. And since being cited, which is less than a month, she's paid more in the time she's been cited to now than she has on 2 years of probation.
All right.
The paper that you scanned, you sent to the wrong address.
Did you move?
No, she sent it to the wrong address. I never knew. So that's how I missed that, because she sent that paper to the wrong address.
Every time you leave my office, you have an mistake, and I write it on the first for you, every single time.
All right. So where we are is October 2022. It was a presumption that you go to prison. But based on that hearing, I found that the presumption of prison was overcome, and I didn't send you to prison. But what I expected when putting you on 5 years of probation is full and complete compliance. And here we are. For whatever reason, there's not been full and complete compliance. Now, what I don't think you understand, ma'am, is that the prison term is still hanging over your head. And that's, I told you, up to 8 years in prison. Now, you can continue to make some excuses about some of the violations. You can continue to not pay the restitution. you can continue to, I know I'm not supposed to drive, but, or you can just go to prison. Your choices are simple. I don't know, I thought they would be easy, but apparently they're not for you. So you have to decide if you're gonna have full and complete compliance. Because failure to do that, you're going to prison for 8 years. Do you understand? So, I still have a capias here on the driving case. You know, I know I'm not supposed to drive, but there's a capias. So I don't know when you got recited to court and all of that, but today there's a capias. So you're gonna have to get it together. And Mom, I know you're here today in support, and obviously you're here supporting her and willing to help her. But maybe you knew about some of this and maybe you didn't know about some of this. But so that you understand, in order to provide support for her, is I expect full and complete compliance. Otherwise, she's going to prison. So, what I'll do is I will continue the sentencing on this to give you time to show the court that you're paying, that you took care of this capias for this driving, and to get things back in order. I'm gonna give you that chance. But if you come back here and there's not full and complete compliance, you're going to prison. The options, there are no options here. You understand? All right. Let's continue this out, Ms. Howard, about 45 days. Now, you haven't moved, and you said that some of the notices went to the wrong address. Can you make sure before you all leave that she has the right address so she can send the notices to the right address if you're able to get that? Ms. Howard, can we get a date? January 7th. January 7th. January 7th. January 7th, 9 a.m. Is that a good date for you, Ms. Mallory?
Yes, Your Honor.
All right, January 7th, 9 a.m. Ms. Mathis, I'll see you back here, January 7th, 9 a.m. And you want to talk to your lawyer about this habeas, and get decided, all right? Thank you. Good morning. This is a matter of State of Ohio versus Sharon Peoples, case number B2402169. Mr. Peoples is present in the courtroom with his attorney, Mr. Matthew McKenna, and Mr. Joe Marshall is present for the State of Ohio. This matter was set today for plea, and I have been handed the plea documents. Mr. McKenna, is this how your client wishes to proceed?
Yes, sir.
All right. And Mr. Peoples, is this how you want to proceed?
Yes, ma'am.
All right, thank you very much. Can I see counsel at sidebar just for one moment? Are you the Sharon Peoples named in this indictment? Are you the Sharon Peoples? Is that your name?
Yes, ma'am.
And are you the person named in this indictment that I?
Yes, ma'am.
And how old are you?
30
All right. And how far did you go in school, Mr. Peoples?
to the 11th grade.
Did you ever obtain your GED?
No, ma'am, I have not been arrested at age 18 right before I was.
All right. Is that something you desire to obtain?
Absolutely.
All right. Are you able to read and write the English language well?
Yes, ma'am.
All right. Are you a U.S. citizen?
Yes.
Have you ever served in the military? Mr. Peoples, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom there are signatures. I recognize Mr. McKenna's signature here, but right above it, sir, is this your signature?
Yes, ma'am.
Mr. Peoples, this is an acknowledgement by you that you have a constitutional right to the trial, which is set for December 9th. Are you okay?
My hands were sweating, that's all.
But when you sign this form, you're indicating to the court, I understand that, but I'm waiving my right to have a trial. I don't want to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with your attorney about your constitutional right to have a trial? Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to have a trial? I also have in my hand a 3-page document, and it's entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page of this document, there are signatures. I recognize Mr. Merschbach's signature here, Mr. McKenna's signature here, but right up here, sir, is this your signature where it says signature of defendant?
Yes, ma'am.
All right. Mr. Prosecutor, would you please put on the record the party's expectation regarding this plea?
State's expectation is that he pleads guilty. State's also informed defense that the state will prefer its sentence.
All right, thank you. Plea is charged, count one?
Yes, Your Honor.
All right, thank you. Is that accurate, Mr. McKenna?
Yes, Your Honor.
Is that your understanding too, Mr. Peoples?
Yes, ma'am.
All right. Sir, are you under the influence of any medications, any alcohol or drugs today?
No, ma'am.
Do you now or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today? Are you making this plea of your own free will?
Yes.
Now, the state has indicated that you are charged in a single count indictment with trafficking in marijuana, a felony of the 5th degree, and that it's expected that you're going to enter a guilty plea as charged. Is that what you talked with Mr. McKenna about before this hearing? Did you have an opportunity to review this 3-page plea form with Mr. McKenna before today's hearing?
Who said it?
Did you have an opportunity to review this
Yes, ma'am.
plea form with Mr. McKenna before today's hearing? Do you understand what he says?
Absolutely.
Do you have any questions about it? Did Mr. McKenna answer all of your questions about it? Mr. Peoples, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today?
I believe so, yes.
And has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review and or discuss the evidence, the discovery that the state has against you with Mr. McKenna before today?
I'm sorry, yes, ma'am.
All right. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
Yes, Judge, to my knowledge, the state has provided everything to defense.
All right, Mr. McKenna, do you acknowledge receipt of same?
Yes, Your Honor.
Mr. Peoples, are you satisfied with your attorney, Mr. McKenna?
Yes, ma'am.
Now, do you understand this charge against you, trafficking in marijuana, a felony of the 5th degree?
I do.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment?
Yes, I do.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being a felony of the 5th degree, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500? Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? And do you understand that if I sentence you to prison and you get out of post-release control and you violate the conditions of post-release control, then you could be returned to the institution for a total of up to 1/2 of your original sentence? You understand that? Are you on post-release control right now? Well, do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. You understand? All right. Do you have any questions? Since this is a felony of the 5th degree, community control or probation is a possibility. Do you understand that I could place you on probation or community control for up to 5 years instead of sending you to prison? Do you understand that if I place you on community control and you that you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. Do you understand? Also, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand? All right. Do you have any questions?
As far as community service and court like court fines and stuff, how would I know how much I owe if I was to have these court fines arrested?
Yes, good question, and your attorney could explain that to you, okay? All right. When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have the constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? All right. Do you understand that if you plead guilty, you are waiving all of these important constitutional rights in this case? Knowing everything the court has discussed with you, do you still wish to enter a guilty plea as charged to trafficking in marijuana?
Yes, ma'am.
Counsel, is there anything further before I accept the plea?
There you go.
May I hear a statement of facts?
Sherrod Peoples, on or about April 24th, 2024, Hamilton County, State of Ohio, penalty sold or offered to sell Schedule 1 controlled substance, marijuana, in an amount that is less than 200 grams. Your Honor, for the court, like any other background assessment.
Yes, please.
Judge, this is part of a joint federal and city of Cincinnati investigation, an attempt to get drugs off the street. They're making drug purchases at high crime areas. The defendant was an individual that did sell to a undercover federal agent. The goal obviously was then to lead guns, but the defendant did not end up furnishing any guns to the undercover federal agent. So that's why he was left with the state charge instead of all the other individuals that went to federal agent.
Oh, okay. All right, those facts, counsel?
No, you're right.
Did you hear what the prosecutor said you did, Mr.
Yes, ma'am.
Peoples? Is it true?
Yes.
What is your plea to count one, trafficking in marijuana, a felony of the 5th degree?
Yes.
Let the record reflect that Mr. Sharon Peoples was present in court with his attorney, Mr. Matthew McKenna, and that Mr. Peoples was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Peoples understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Sharon Peoples guilty as charged, count one, trafficking in marijuana, a felony of the 5th degree in violation of Revised Code 2925.03 subsection A1. Counsel, is there any reason why sentence should not be entered today?
No, you're right.
All right, are you waiving the PSI?
Yes, you're right.
Any objection by the state? All right, on the sentencing findings of Mrs. Howard. What would you like to say on behalf of Mr. Peoples?
As I said, Your Honor, he's 30 years old. He has 2 children, 11-year-old son, 4-year-old daughter. He gets his son off the bus every day, sees his daughter every other weekend, I think, on the weekends. This particular situation was hanging out with the wrong people. He does have a little bit of a record, no prior drug involvement anywhere. This is something that is just hanging out with the wrong people. He has a job now, working 35 to 40 hours a week.
Doing what?
He's at Taco Bell. He's previously been a manager at McDonald's, but that's his industry. He works in, but he's at 35. And we just asked for appropriate community control. He does have prior felonies. The first one, as he referenced, was back when he was 18, 12 years ago. And the second, and more recent, is the weapons under disability. But again, no prior drug involvement for all those years. And we were just asking for appropriate community control.
Thank you. State.
For you, Judge.
All right, Mr. Peoples, is there anything you'd like to say before I pass sentence? So you have 2 kids? One's 11, one's 4? All right, which one lives with you?
My son,
Which one, how old is he?
he's 11.
Oh, the 11-year-old, okay.
So, he's older than me, bunch of other kids, and he kind of got like, they need to take meds, so he's hyperactive.
Mhm.
He got short attention span. So
Okay.
if he doesn't know about it, he just,
Okay,
he'll be out that way.
well, you know what? A lot of people have short attention spans. My question to you is, as a father, what are you showing him?
Not the father, not the, just.
So you want that whole do as I say, not as I do? That ain't gonna work. Not for kids today.
I know, and
That never works.
I'm still learning that too, because like I said, I've been where he is, I just getting older and seeing the stuff that's going on. I don't want to go down that same road.
Well, you better figure out what type of father you're gonna be.
Still working on it.
Because that do as I say, not as I do, it never works, okay? And what does work is what he sees you do, that's what he's gonna do. Because no matter who you are to the world, you're his hero. So if you do it,
He don't think it's cool to me.
mhm.
No,
And do you want your son standing in front of a judge?
absolutely not.
Well, then you better show him different.
I'm making I'm making a little bit of progress. But
Well, you don't have time to make little progress. You don't. You have no time to make little progress. You gotta get it together today, because he's 11. And you're getting ready to go into some difficult years with him as a teenager. So you don't have time to make little progress. You have to show him the way. And either you're gonna show him the way, either way. You understand what I'm saying?
That's right.
So you can either show him the right way, or you can just show him what you've been doing. But either way, you're showing him the way.
I'll go with you right away.
Well, you better figure it out today. You don't have time, no more time. So, the court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. And I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Peoples, I hereby sentence you to a term of 2 years, community control, intensive supervision. That intensive supervision is so you can speed up that whole progress.
You might have asked a question.
Hold on, I'm not finished.
Okay.
Intensive supervision. You will pay court costs. I will not issue a fine. Now, Mr. Peoples, you're gonna be, have to submit to drug and alcohol testing while you're on probation. Is that gonna be a problem? Okay, great. So if it is a problem and you violate the conditions, then I will not hesitate to sentence you to a term of 12 months in the Ohio Department of Corrections. Do you understand?
Yes, ma'am.
All right. Now, what would you like to say, sir?
I was just, I was thinking about, so you already answered the question, but now I was trying to ask you about the fine costs. You said you were,
Yeah, the clerk can tell you how much that's gonna cost, and you can pay that during the term of your probation. I'd like you to pay it as soon as possible, but you can pay it over the term of your probation, okay? And, anything else, counsel? State, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, then an attorney will be appointed to help you at no cost to you. Do you understand? All right. I wish you well. You'll need to go over to probation to sign up. It won't take but a few minutes. But this is to help you
with the steps.
with those steps. That's right. All right?
I appreciate it.
He's going to show you. All right. Thank you.
Thank you.
Thank you. Dante Williams? Your lawyer here? Is Miss Hunter here? Where's Miss Hunter? Okay. Mr. Williams, can you just hold on for one moment? Miss Hunter's not here, but Mr. Williams, I'm still talking to you. You walk away. No, I want you to hold on. So I was going to ask you just to hold on for a moment. Your attorney is not here, but she's sending someone in her place because she's not in today, and they're going to be here in just a few minutes.
No, the lady is already here. We went to the restaurant.
That's Miss Ellis, so she has to come back. You understand? I can't have a hearing with you without a lawyer present. Do you understand? Okay, so just a few minutes. Okay, thank you. All right, Mr. Trent. Mr. Trent, right? He's not here. Good morning. How are you? How are you?
I'm all right.
I'm ready.
Okay, we can call when court is ready here.
All right. This is the matter of State of Ohio versus Eric Thompson, case number B 240236. Mr. Thompson is present in the courtroom with his attorney, Mr. Craig Teepin, and Mr. Joe Prim for the state of Ohio. This is set for trial today, gentlemen. Are we ready?
Your Honor, defense is ready with me, and not really.
All right, Dave?
The state is not ready to know. We're in the unenviable position of needing to request a continuance. I have a number of uniformed and ununiformed members of the Cincinnati Police Division present. This is a case where the pivotal witness and the pivotal evidence comes from a private witness who is a juvenile. I've subpoenaed that juvenile. I've also subpoenaed the legal custodian of the juvenile. That's an Amber Knight. She's not present today. In the abundance of caution over the month leading up to this hearing, I called and left 2 different voicemails for Ms. Knight. I received no response whatsoever. Officer Schuyler from the Cincinnati Police Division is present as well. At my direction about a month ago, he also began reaching out to the legal custodian to ensure her appearance today or answer any questions. He's also received no response. As it stands, I cannot go forward on these charges.
Okay, so the endangering children, those 3 separate minors?
No, it's
One minor,
alternative charges for one.
one minor. And the lunch assault is also against the minor?
It arises from the same animus because one of them alleges that there was a reckless creation of a risk of serious physical harm, which you can have serious.
So this is one incident,
It
one
is.
victim,
One course of conduct, right, yes.
2 victims?
One victim, one course of conduct.
Okay, all right, and the minor has a custodian, and the custodian is not responding.
That's correct, and again, because I feel I owe a duty of candor to the court, in reviewing the case materials for this case, I've been in contact with the Department of Jobs and Family Services, who closed out on this thing when legal custody was awarded. I've had a chance to review the 911 tapes. I know that this person was actively involved. I cannot explain her absence because I have not heard from her. In her absence, I cannot go forward.
Is the custodian's mother?
No, it's an aunt,
It's an aunt.
yes.
And what is the relationship here? with
I don't know
defendant-
if it's a maternal or paternal.
With defendant,
I'm not sure.
Whose relationship? To the alleged victim?
and the aunt,
Is his daughter is the alleged victim. Aunt is daughter's mother who passed away, sister. So maternal aunt.
sister. Okay. So the state is, well, you sent a subpoena, right?
Yes. I actually sent one. I sent 3.
And, you're asking me to continue this?
Given the
Or you
gravity,
just saying you can't go forward?
I can't, given the gravity of the charges, at least for the record, I feel compelled to, but I also feel compelled to make the court aware that this is not for lack of trying.
All right, may I see counsel sidebar?
So she lives in Edinburgh. No, so we've been calling nonstop, but I can't get personal services. It's not personal sense. Mail, call me a number of times. I check JMS to try to make sure contact with JMS. We just can't make contact.
she was 14 when this started. She's trying to I don't know the answer. Well, he has to stay through this case, so this one, he's still, actually, it's been doing very long, she's at, so he's been, yeah, I don't know. So just for our quick the factual, factual allegations is discipline. She felt that it was too long. She called me, texted me, called my district house out. And our it's mostly scratches and actual after. Pictures. Okay, so good, he does, she does the second time, but the big intro. That's how, and then that's the other, without the historical qualification, I'm inclined. The explanation, I noticed that now she's got, just from that full family. So she's, I can't say that, sure, but that makes sense. Understood that.
Thank you. All right, the state has made due diligence in fact, an overabundance of diligence in trying to get the prosecuting witness present. This matter was set for trial, it's been set for trial for quite some time. And the defense is ready to go, state cannot proceed, this matter is dismissed from our prosecution.
Thank you.
Thank you. This reference,
I'm just waiting for my client.
okay, good.
She has 2 cases.
Mr. Sawyer, Mr. Fox, can I speak with you when you get a moment? Go ahead, you can finish doing what you're doing when you get a moment.
brings into it. There's still. There are numerous. Share the court's concern. This was a little different. Yes. Later that day, he came back. And they arrested him. She made additional application. So, this was early in the morning. This was shot.
This is a matter of State of Ohio versus, is it Carisi? Perez Mizell. Case number 2404060. Mr. Mizell is present in the courtroom with his attorney, Mr. Brandon Fox. Mr. Christopher Sawyer, present on behalf of the State of Ohio. This matter is called for jury trial today. And is the defense ready?
We are.
All right. And the state.
Your Honor, state is unable to move forward this morning. In full candor to the court, on October 2nd, the prosecuting witness in this matter did reach out to our office. She indicated she wants the case dismissed. She is not present today. I do have officers present. We have made attempts to call her with none of those attempts being come to fruition. So that being said, Your Honor, the county would respectfully request a continuance in an attempt to get personal service on the prosecuting witness.
Defense.
We will move for a dismissal, Your Honor. Thank you.
So the prosecuting witness reached out to the state and said she wanted this case dropped.
That's correct, Your Honor, on October 2nd. That is the note that I have.
I can add additional context because Mr. Sawyer was not on the case early on. Prior to its indictment, the alleged victim contacted my office and indicated, I cannot speak with you about this matter. You need to call the prosecutor's office. She indicated at that point she has attempted to contact the victim's advocate that she had been provided and provided this information to the victim's advocate prior to indictment as well.
Mr. Mizell, you are before the court and today was your trial for one count of strangulation. Now, the state, as you've heard, is indicating they can't go forward because they don't have a cooperating witness. In fact, the alleged victim wants the case dismissed. Now, you may think, oh, great, but I see right through cases like this. Let me just tell you, today, I'm prepared to dismiss the case, but I want to I'm choosing my words carefully because I want to say warn you, but I'm going to say I'm going to give you some advice. Don't come back to this court with strangulation, domestic violence, assault, or any type of violent behavior, allegation. Do you understand? Because it will come to me. Now, I don't know if this is true or not. You are presumed innocent as you stand here, innocent of the charge. But I don't like these charges and these allegations. That doesn't necessarily mean you did it. It's just I don't like it. So, what you can do is to make sure that you don't catch any of these charges or types of charges again. Do you understand? Do you really? All right. The matter will be dismissed for one prosecution.
Thank you, Your Honor.
This was, yeah. I know, but Miss Ellis, Mr. Williams is here. Yeah, okay. Here she is. I know you're ready, Mr. Tractor, to call you right now. I just wanted to get Miss Ellis here because Mr. Williams has been waiting a long time.
I'm okay.
Okay, thank you. It's the matter of State of Ohio versus Dante Williams, case number B 2403398. Mr. Williams is present in the courtroom with attorney Brittany Ellis, who is covering for attorney of record, Ms. Sharon Hunter. And Ms. Ellis, and Mr. Christopher Sawyer for the state of Ohio. What we have is a trial date set January 13th and a final pretrial conference date set January 9th. Ms. Hunter, oh, wait a minute. Ms. Glazer, I thought was a phone. It could work out.
She was supposed to, but you asked us to have Mr. Kennedy.
Oh, yeah, okay. All right, so Ms. Hunter was appointed. There is a motion to suppress that was filed. We would need to schedule that if Ms. Hunter wants to go forward with it.
I saw that, Your Honor. I assume she wants to go forward with that. I haven't spoken to her about it directly. We could go ahead and schedule it. If it turns out she does not wish to do the motion, her client will let the court know. as soon as
All right.
possible.
I think that's the most prudent course of action because we don't want Mr. Williams' case to stand still.
Right.
So let's set a motion to suppress before January 9th. Now, Mr. Williams, given the holidays coming up, we'll see how we can get the scheduling, okay? That's Wednesday, December 11th. I thought is there something on the court has a the court?
Before that.
The 11th is, what time is that?
Well,
12 to 1:30. Anything in the afternoon?
as of right now.
Okay. All right, let's set it for December 11th. What? At 10 o'clock that day? Well, that's fine. We're just gonna go ahead and set this for 10 o'clock, motions to suppress. Ms. Hunter will let us know if that date works for her.
Yes.
She'll also know if it's still a viable motion, she wants to go forward. Please let her know to let me know.
Yes,
And if it's not, then we'll figure it out.
absolutely. I'll tell her today.
Okay, there was nothing that, I think the first 2 weeks in January is that no mid-mile case.
That's the last 2 weeks.
Okay, what was,
The first week is just a week trial.
okay. All right. 'Cause I think 11 is not going to work really, to be honest.
We can do it on the 8th.
The 8th is a Wednesday?
Yes.
What was the 11th?
January.
Oh. Yeah.
I'm sorry, we
January.
the jury.
No, the motion to suppress.
Oh, understood.
The final pretrial conference is the next day, so the 9th, so the jury trial will be the next week, but we can do it on the, January 8th. I think it would be better because I don't want to double book myself on the 11th when I know I have something else at 10 o'clock. And I want to be able to give my full attention to Mr. Williams' case, so can we do it January 8th? All right. Does that work for you, Mr. Sawyer?
Yes, sir.
All right, January 8th, 25, and that's at 10 a.m. Mr. Williams, there are no court dates between now and January 8th, okay? So I don't want you to worry about coming to court the rest of this month or next month. But January 8th is your next court date. Please stay in contact with Ms. Hunter as you both prepare for the motion to suppress hearing, okay? All right. Anything else, council?
No, Your Honor.
All right, anything?
Nothing stated.
All right, thank you very much. Thank you for your patience, Mr. Williams. And this, okay, I did Vincent Brandy is gonna be my next one, just a second. Mr. Tranter, just give me 2 minutes.
Yes, sir. I mean,
Yeah.
what's this, sit back down?
No, no, no.
Okay.
You can't watch it, but just 2 minutes. This is a matter of State of Ohio versus Vincent Brandy, case number B2402502A. This matter is set for jury trial today, but I can hand you plea documents and is this how your client wishes to proceed, counsel?
Yes, sir.
All right. Are you the Vincent Brandy named in this indictment? Mr. Brandy, how old are you? And how far did you go in school?
I graduated.
So you're able to read I'm sorry?
I graduated with you, I'm still in high school.
All right, thank you. And so you're able to read and write the English language well? Are you a U.S. citizen? Have you ever served in the military? Mr. Brandy, I have in my hand a single-page document, and it's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Tranter's signature here, but right above, sir, where it says defendant, is that your signature? Can you see it from there? You can step up.
Yes.
All right, thank you. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to have a trial. I don't want to have a trial today. Is that your understanding of what we were doing when you signed this form? Did you sign this form after you consulted with Mr. Tranter about your constitutional right to have a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to have a trial? I also have in my hand a 3-page document, and it's entitled Entry, Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Mr. Sawyer's signature and his bar number right here, Mr. Tranter and his bar number right here, and you can step up, sir. Is this your signature here where it says signature of defendant? All right, thank you very much. Mr. Prosecutor, would you please put on the record the party's expectation regarding the plea?
Your Honor, tonight's expectation with the court's permission, the defendant will be entering a plea of guilty as charged to the indictment. It's improper handling of firearms in a motor vehicle, felony of 4th degree violation of Revised Code Section 2923.16 parens B, and the firearm will be forfeited.
All right, thank you. Mr. Tranter, is that accurate?
Yes, sir.
Mr. Brandy, is that your understanding too of what's to happen today? All right. Sir, are you under the influence of any medications, any alcohol or drugs today? Do you now, or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty today? Are you making this plea of your own free will? The state has indicated that you are charged in a single count indictment with improperly handling a firearm in a motor vehicle, a felony of the 4th degree, and that it's expected that you're going to enter a guilty plea as charged. Is that what you talked with Mr. Tranter about before this hearing today? Did you have an opportunity to review this 3-page plea form with Mr. Tranter before this hearing? Do you understand what it says? Do you have any questions about it? Did Mr. Tranter answer all your questions about it? Mr. Brandy, do you believe you had enough time to sufficiently consult with your attorney about your entire case before this hearing today? And has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the evidence, discovery the state has against you with your lawyer before today's hearing? Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
Your Honor, all discovery the state has in its possession, along with any Brady material, has been provided to the defense.
Mr. Tranter, do you acknowledge receipt of same?
Yes, sir.
All right. Mr. Brandy, are you satisfied with your attorney, Mr. Tranter? All right. Now, do you understand this charge against you, improperly handling a firearm in a motor vehicle, a felony of the 4th degree? You understand that charge? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment? Do you understand? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and just proceed to sentence you immediately? You understand? Now, this being a felony of the 4th degree, do you understand that you're facing up to 18 months in prison and up to a maximum fine of $5,000? And do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now? Well, Mr. Brandy, if you are on post-release control and you committed a felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term, or whatever time remains in your post-release control time, or whichever is greater. Do you understand? All right. Do you have any questions? Since this is a felony of the 4th degree, community control or probation is a possibility. Do you understand that I could place you on probation or community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions, then you would have to be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 18 months I previously discussed with you. Do you understand? Also, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand? All right. You have any questions? When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand each of these rights that I explained? Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? Do you understand that if you plead guilty, you are waiving all of these important constitutional rights in this case? Mr. Brandy, knowing everything the court has discussed with you today, do you still wish to enter a guilty plea as charged to the single count indictment, improperly handling a firearm in a motor vehicle, a felony of the 4th degree? All right. Counsel, is there anything further before I accept the plea?
No, Judge, thank you.
All right, may I hear a statement of facts?
On or about May 28, 2024, in Hamilton County, State of Ohio, the defendant Vincent Brandy knowingly transported or had a loaded firearm in a motor vehicle in such manner that the firearm was accessible to the operator or any passenger without leaving the vehicle. It's improper handling of firearms in a motor vehicle in violation of revised code section 2923.16b, a felony of the 4th degree.
All right, anything on those facts, counsel?
No, Judge, thank you.
All right, Mr. Brandy, did you hear what the prosecutor said you did? Is it true? All right. What is your plea to count 1, improperly handling a firearm in a motor vehicle, a felony of the 4th degree? What's your plea? Let the record reflect that Mr. Vincent Brandy is present in court with his attorney, Mr. Tranter. And, Mr. Brandy was informed of all of his constitutional rights and has made knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Brandy understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Vincent Brandy guilty as charged in count 1, improper handling of a firearm in a motor vehicle, a felony of the 4th degree, in violation of revised code 2923.16 subsection B. Counsel, is there any reason why sentence should not be entered today? Want to waive PSI?
Yes.
All right. What do you want to say on behalf of Mr. Brandy?
Judge, as he indicated, he's 23 years old, lives in the Roselawn area with his family. The last week here in court, they were here, and we acknowledged them here again this morning. Very supportive family. He's got a job at DHL, Judge. I'm hoping that this job is not affected by this charge.
What does he do at DHL?
He's a forklift driver. And he does have his diploma, as indicated, Judge. Very cooperative with me as his attorney. We've gone over the case significantly over the last several weeks and months. I think the officers have been consulted, Your Honor. I don't think they're taking any position as far as sentence. He's never had a prior felony, Judge. So we would like to see him get a chance on probation here, Judge. I think he will report. He's always come to my office on time. He's been at court here promptly and early. He'll do anything that's required of him as far as probation. If you give him that chance, Judge, we'll submit on that.
All right, thank you very much. Anything from the state?
Your Honor, just one point of clarification. First of all, he does have a prior juvenile felony adjudication for attempted carry and concealed weapon that was amended from carry and concealed weapon felony to 4th degree down to an attempt in 2018. Prior to that, the defendant was also convicted of carrying concealed weapons in front of Judge Triggs in 2021 as well. That started as a felony. He received a reduction to a misdemeanor of the first degree. The associated improper handling of firearms in a motor vehicle for that case was also dismissed. In this matter, Your Honor, it was approximately 2 in the morning. Officers received a call for a domestic disturbance. They walked up to the vehicle that the defendant was the driver in to attempt to determine whether or not he was the individual involved in the domestic disturbance. When officers looked at it, not only did they see the firearm at his feet in the vehicle, they also located drugs. I'm not sure if the defendant was not charged with those, but I'm not sure if his passenger was charged with drugs as well. But ultimately, Your Honor, I will be asking that the court forfeit the weapon and will defer to the court for sentencing. But I just want to give the court context of the evening that the officers encountered.
And just to be clear, Judge, the domestic stop did not involve him. That is correct. If there was someone else they thought was him, then they were checking on him for this unrelated incident.
I see.
I just want to make sure it's clear on that.
And this was where?
This was $1793 Crestville Avenue in Cincinnati.
That's, Roselawn. You live on Crestwood? Were you in front of your house?
No, I was, I live there.
Oh, I see. All right. All right. Anything else on the facts?
Yeah, Judge.
Your prosecutor said you did? Is it true? What's your plea to count 1, improper handling of a firearm in a motor vehicle? Okay, I think you did that already. Okay, I'm sorry. It's not feeling well today. All right. All right, let the record reflect that Mr. Vincent Brandy is present in court. Did we do that already? No. You didn't do it in the beginning. I didn't do it in the beginning, but you did. Sorry. All right. Did you tell me what you wanted to say? And now I know about him. You told me what you wanted to say. Now I want to hear from Mr. Brandy. Is there anything you want to say before I pass sentence? Okay, so let me go back to, you were in front of your friend's house at 2 in the morning with a gun on your floor? Okay, tell me why.
The reason for that is because in my neighborhood, we got innocent people that get hurt and targeted for no reason. And the gun I had is like a standard. I don't have extra ammo in my clip. I don't have a button that make it automatic. But I got people, a whole lot of people in my neighborhood that do. A whole lot of people in the city that do.
So, okay.
I just, protect myself and make sure I'm good. So I can make it home.
So, I definitely sympathize with that circumstance. But I just have a couple of questions. So, if you're doing nothing and you're just innocent and someone shoots you, you think you having a gun is going to de-escalate the situation, or you think it's gonna ramp up?
I know it's at least a small possibility that I can save myself from a situation of being harmed or
Mm-hmm.
I'm not looking for trouble.
Well, I get that.
But I gotta protect myself.
So, are you saying we're gonna do this again?
Unless I get everything clean and I can carry it the right way, get concealed carry license, that's what I'm going for.
Okay, well, that's the process.
Yeah,
What you gonna do between now and then?
I'm gonna carry a gun.
Yeah, but you still live in the same neighborhood,
Yeah, so.
and you still have the same bad people in the neighborhood who have those guns with clips that you just told me about that you're protecting yourself from. But now you're saying, but I'm not gonna carry it.
Because I ain't gonna risk my freedom, right? The only reason I had it, because I didn't know that law came into effect where my juvenile record or whatever it takes to be passed, that was changed. I tried to stay tuned in with the new or updated laws, but I didn't hear about that.
Well, they didn't charge you with having weapons under disability. That's what you're doing now. They charge you with how you had the weapon in the car, right? But now you can't. You know you can't, but your circumstance hasn't changed.
Judge, one of the things we talked about pretty significantly is this case is going on is what the current law is as far as guns.
Mm-hmm.
And I would say, I think it's confusing as a lawyer even sometimes to figure out the way to handle things and the way to keep just being straight.
Mm-hmm.
You know, it changes pretty significantly for the last year or two.
Yeah, I
We
agree.
talked, my point is, with him, gone over. He was handling it completely the wrong way.
Yeah, I don't expect him to know all the laws. What he's telling me about is a circumstance that is his reality. And that reality is you live in a neighborhood where there's high crime and you're trying to protect yourself. But now you know that you cannot have a gun. So what are you going to do? Because let me tell you what I see happen. You walk out of here, if I give you a chance, and then you have another gun, because you're going to protect yourself. That's what I see. And then you come back with a having weapons law under disability, and then I have to put you in prison. So, that's why I'm asking you these questions. So you consider what you're gonna do. Because having a gun is not an option. So, this is what you have to consider. Now, I don't know if that means moving. I don't know if that means how you move. You know what I mean by how you move, how you navigate yourself while living in the same neighborhood, in the same place, just to ensure or increase your safety. But these are things you gotta think about. Because now you gotta take having a weapon off the table. Right? There are lots of people that live in your neighborhood and lots of neighborhoods in the city where there are bad people carrying guns, and there's a higher risk that someone could get shot, an innocent person. I get it. But in those neighborhoods, there are people who don't carry guns. See what I'm saying? So now you got to figure out some strategies of how you're going to keep yourself safe without a gun. I don't know if that means, you know, you can say, well, it's unfair, I'm young, I'm going to stay out till 2, 3 o'clock in the morning. It increases your chance. Sorry, it's unfair, but it does. You understand what I'm saying? But you have to figure out in life how you're going to navigate this. Maybe I'm not going to come in so late. I don't know. Maybe I'm going to move. Maybe I'm going to make sure that, you know, I park in a garage or I park behind my building so that I'm not in the front and people can see me when I come in. I don't know, but you got to figure it out, is what I'm trying to say. Because you got to take the gun part off the table. Okay? So think about that. Anything else, counsel?
No, Judge, thank you.
All right. The court has considered overriding purposes of felony sentencing pursuant to revised code 2929.11. The charge to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. And I have reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the recidivism factors and the seriousness factors as set forth in revised code 2929.12. Accordingly, Mr. Brandy, I hereby sentence you to a term of 2 years of community control, which is probation, intensive supervision. They have a course in probation. It's called cognitive behavioral CBI, but it has to do with your thinking. It helps you with thinking. Not to say you think badly, but to help you think through those questions I was just talking to you about, help you think through those. Costs and fines shall be remitted. You won't have to pay court costs and fines. And if you violate, come back in here with a gun charge, I'm sitting in prison for 18 months. You understand? Plus consecutive to whatever other charge, if there is another charge. I'm hoping there won't be, but if there is, it's gonna be consecutive, okay? All right. Now, anything else, counsel?
Our weapon be ordered forfeited.
The weapon will be ordered forfeited.
We have done 2 forms, you Judge.
Yes, thank you. Anything else?
No, that's fair.
All right, Mr. Brandy, you will right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. You understand? Now, I told you the bad part of if you violate. Let me tell you your incentive. If you do well on probation, you're not even at 2 years. I'll consider releasing you off early. Okay? All right. I just want to see you know, do what you need to do, figure out some strategies, stay out of trouble. Okay? All right. I wish you well. You need to go with probation. from order, we go pursue through their processes. Ms. Ellis, you have two cases. Ms. Rathme Alexander, you have case. All right, who's ready? Anybody?
I'm ready, Judge. It's my stuff to be fast.
Your stuff is fast.
It's not fast.
Oh, it's not fast?
It's not fast.
Okay. All right, then we'll hold up on you for a second. Ms. Alexander? Ms. Ellis, your client here? Your client here?
He is here, Your Honor.
Okay. Making sure. Thank you. Is Victor here, please?
Yes, Your Honor.
She is on. This is a matter of State of Ohio versus Montez Johnson, case number B 2402462. Mr. Johnson is present in the courtroom with his attorney, Ms. Rathane Alexander, Mr. Christopher Sawyer from the State of Ohio. And it's my understanding that the alleged victim is present as well.
That is correct, correct. On the record, that Ms. Jennifer Hughes is present, she is standing next to the railing behind Ms. Britton.
All right, thank you. All right. This matter is set for a jury trial today, but I've been handed plea documents. Is this how your client wishes to proceed, Ms. Alexander? Mr. Johnson, is that true? All right, you stand close to the microphone. All right. Are you the Montez Johnson named in this indictment? Mr. Johnson, how old are you? 23? How far did you go to school?
I graduated from high school.
Which high school?
The Bachus Lorraine.
Where?
The Bachus Lorraine, down here. It's my home school.
Oh, where is it located?
In Clifton.
Oh, in Clifton area?
Yeah.
Oh, I see. I've never heard of that. Are you able to read and write the English language well? Are you a U.S. citizen? Have you ever served in the military? Mr. Johnson, I have in my hand a single-page document entitled Waiver of Trial by Jury. The bottom there are signatures. I recognize your attorney, Ms. Alexander's signature here, but right above, right here, is this your signature? Can you see it from there?
I really can't, but.
Well, then you need to step up to this, separate right there. Is this your signature?
Yes, ma'am.
All right, thank you. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that I don't want a trial. I'm waiving my right. Is that your understanding of what you were doing when you signed this form? Did you sign this form after you consulted with your attorney about your constitutional right to have a trial? You have any questions about this form? Do you have any questions about your constitutional right to have a trial? All right. I also have in my hand, it's a 3-page document, but it's not stapled. So I have a 3-page document. And on the front, it's entitled Entry Drawing a Plea of Not Guilty, Entering a Plea of Guilty. Thank you. And on the 3rd page, there are signatures. I do recognize the prosecutor, Mr. Sawyer's signature here, his bar number, Ms. Alexander, your lawyer's signature here, but up here, can you step up a little bit? Is this your signature right here?
Yes, ma'am.
All right, thank you. Mr. Prosecutor, would you please put on the record the party's expectation regarding the plea?
Yes, Your Honor, it's kind of expectation on the court's permission, the defendant will enter a plea guilty to an amended charge of attempted theft in violation of the Code Section 2923.02. To be reduced from a felony of 4th degree to a felony of 5th degree.
All right, thank you very much. Counsel, is that accurate? Mr. Johnson, is that your understanding? Now, are you under the influence of any medications, any alcohol or drugs today?
No.
Do you now, or have you ever had to manage any type of mental health difficulties?
I did.
Can you tell me about that a little bit? Step up closer to the microphone.
I did.
Well, hold on. I was going to split it up a little bit so you don't have to bend down. Great. And make sure it's on. Okay.
Yes, ma'am, I did. I was hospitalized with a mental health issue.
All right. When was that?
Hopefully last year, or the beginning of this summer.
All right.
And I was dealing with that like this summer. I had medicine and everything. I just didn't go back and get on the field or anything like that.
And can you tell me what you were diagnosed with?
I don't know it off the top of my head. It's something around anxiety, something like that. I've been at ADHD when I was younger, stuff like that.
Are you on medication now?
I haven't gotten refilled.
Why not?
I just haven't felt the need to, have to take them.
Okay. So you're not really sure of the diagnosis? I think we had a competency, done on him, and he was found competent to stand trial.
From the notes, if I may, Your Honor,
Yes.
from the notes that I have from the previous counsel, when he was admitted back in May, looks like it was for anxiety and ADHD.
Yes, ADHD and anxiety. All right. And, you have medication, what you want to do?
I just haven't went back to get them refilled.
Okay. Are you presently under any type of probation or community control supervision in this state or any other state? Can you tell me about that?
I have the EMU.
You have EMU from my court?
Yes.
Yes.
But has anybody put you on probation before? Are you on probation now?
No.
All right. Has anyone threatened, forced, or coerced you, made you in any manner enter this plea of guilty today?
No.
Has anybody promised you anything at all? Promised you what I would do if you entered a guilty plea?
No.
Are you making this plea of your own free will? Meaning, are you doing it because you want to? All right. The state has indicated that you are charged in one count of theft. It's a felony of the 4th degree. But based on your attorney's negotiation with the state is asking the court to reduce it from a felony of the 4th degree to a felony of the 5th degree. Is that what you talked with Ms. Alexander about before this hearing today?
Yes.
Did you have an opportunity to review this 3-page plea form with her before this hearing today? Do you understand what it says?
Yes.
Do you have any questions about it?
No.
Did Ms. Alexander answer your questions about it?
Yes.
Mr. Johnson, have you had enough time to consult, to talk over your entire case with your lawyer before today?
I don't think so yet.
All right, has your lawyer answered all of your questions to your satisfaction? Is there anything you asked that she couldn't answer? All right. Have you had an opportunity to review or discuss the evidence, discovery the state has against you with Ms. Alexander before today's hearing?
I think I looked at it.
Okay. Ms. Alexander, do you want to put anything on the record with regard to that?
We've discussed the pros and cons of moving forward with the trial versus entering a plea, so I would say.
All right, thank you. Mr. Prosecutor, please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, at all, to your knowledge, to the defense?
Your Honor, the state has provided the defense all discovery it has in its possession, as well as all Brady material evidence to the defense.
Thank you. Mr. Johnson, are you satisfied with your attorney, Ms. Alexander?
Yes, I'm waiting.
All right. Now, do you understand this charge that's been reduced to a felony of the 5th degree? Do you understand this charge of theft?
Yes, ma'am.
And do you understand that if you plead guilty, you are making a complete admission that you committed the allegations of theft, felony of the 5th degree?
Yes, ma'am.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, this being reduced to a felony of the 5th degree, do you understand you're facing up to 12 months of prison and up to a maximum fine of $2,500?
Yes, ma'am.
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? And do you understand that if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence? You understand? Are you on post-release control right now?
Yes,
Post-release control, not the ankle monitor.
no, I'm not.
All right. Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand that? Do you have any questions so far, Mr. Johnson?
I don't.
All right. Since this is a felony of the 5th degree, it's being reduced to a felony of the 5th degree, do you understand that community control is a possibility? That's probation. And that I can place you on probation or community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control or probation and you violate the conditions, then you will be brought back before me for a more restrictive sanction, which could include a whole host of penalties, but the most severe penalty is the imposition of prison time up to 12 months that I previously discussed with you. Do you understand? Also, Mr. Johnson, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand that?
Yeah.
Do you have any questions so far?
I don't.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which is set for today, either to the court or to a jury of 12 persons?
My last birthday, I was supposed to have a discovery.
Do you understand my question?
What was your question? I'm sorry.
My question is, do you understand that you have a constitutional right to have a trial today? All right. Do you understand that you have a constitutional right to confront witnesses here in open court and have your lawyer cross-examine them? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? Do you understand? And finally, do you understand that at a trial, you can't be forced to testify against yourself? Do you understand?
Yes.
Do you understand each of these rights as I explained them?
Yes.
Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today?
No.
All right. So we talked about a lot today, Mr. Johnson. Knowing everything the court has discussed with you, do you still wish to enter a guilty plea to the reduced charge of theft, a felony of the 5th degree?
Yes.
Counsel, is there anything further before I accept the plea? All right, may I hear a statement of facts?
Sure. On or about May 26, 2024, in the Hampton County, State of Ohio, the defendant Montez Johnson purchased the privately owned or certain property or services to wit, a motor vehicle belonging to Jennifer Hughes, knowingly obtained or exerted control over such property or services without the consent of the owner or person authorized to give consent. Theft in violation of revised code section 293.0281, now a felony.
All right, anything on those facts, counsel? All right, Mr. Johnson, did you hear what the prosecutor said you did?
Yeah, no.
All right, is it true?
Yeah.
All right, what is your plea to count 1, theft, reduced to a felony of the 5th degree?
I'm guilty.
Let the record reflect that Mr. Montez Johnson was present in court with his attorney, Ms. Raffaele Alexander. and that Mr. Johnson was informed of all his constitutional rights in the state of knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Johnson understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Montez Johnson guilty to theft reduced to a felony of the fifth degree in violation of Revised Code 2913.02.
Attempted theft, Your Honor, 2923.02 for the attempt section.
That's the attempt section?
Yes, sir.
Okay, that's what's on this form by Ms. Alexander, so I'll have to. All right, I'm sorry?
Oh, that's not my
In violation of 2913.02. Why is that not right?
I thought, Your Honor, I apologize. I thought you said theft instead of attempt.
Oh.
If I'm confused.
Is this an attempt?
That was my understanding. We were going to be doing a attempt theft reduction of five.
Okay.
Is that correct?
Here you go. You guys look at the paperwork. I'm going off your agreement.
Mr. Your Honor, we can leave it as theft of felonies with 50 degree instead of attempt.
Okay. So I was correct. In violation of Revised Code 2913.02. All right. Counsel, is there any reason why sentence should not be entered today?
I don't believe so, Your Honor. We would ask to move forward.
Are you waiving the PSI?
Yes, please.
All right. What would you like to say on behalf of Mr. Johnson?
Your Honor, may, before we proceed to sentencing, may I just confer with the
Sure.
victim to see if she wishes to speak with, based on the
I was going to ask that too.
Excuse me one second.
Okay.
And after consulting with Ms. Hughes, she is waiving the victim impact statement, and she has indicated she does not wish to speak.
Okay, thank you very much. All right, what would you like to say on behalf of Mr. Johnson?
Thank you, Your Honor. Mr. Johnson is 23 years old, doesn't drive here in Cincinnati, Your Honor. He was doing some seasonal work that has ended. He tells me that he does have some interviews set up at the TQL Stadium, also at McDonald's. So he's hoping to hopefully get a yes to one of those jobs so he can restart employment, Your Honor. I do not show a criminal record for Mr. Johnson. As he kind of talked about briefly, right around the time that this happened, he was admitted to UC for mental health, Your Honor. Granted, he was given medication. He did let the court know that he wasn't taking that medication. I kind of advised him that he had the idea to kind of restart that treatment to make certain kind of stays on the right path. I do believe that kind of the mental health kind of played a big part in what happened here, Your Honor, being that right after this occurred, he was admitted to the hospital. He is here taking ownership and responsibility for his actions, Judge. As stated previously, he has no previous history, so this was pretty unusual for him, Your Honor. He understands that he is apologetic to the witness. He has been on interview, to my knowledge, without any issues. So I do believe that that is a precursor that if you were to put him on probation, he would continue to follow the court's order and do well on probation. So in lieu of any jail time, we would ask that you would consider a period of probation due to his lack of record, him taking responsibility for his actions, and the fact that he has done well during pretrial status and following the orders of the
All right, thank you very much. State.
Your Honor, as it pertains to the defendant's record, he does not have a juvenile history that I can see, and the only other contact with the criminal court has been a disorderly conduct ticket, which we paid out. In speaking with Jennifer Hughes, she does not have an opinion one way or the other on sentencing, and she has indicated there is no restitution being sought.
All right, thank you very much. All right, I will note for the record, Ms. Jennifer Hughes is present, and, Mr. Johnson, anything you want to say before I pass sentence?
No.
Really?
I want to apologize
To the court?
to Ms. Hughes.
You didn't take my card. Well, you don't even know where she is.
I apologize to you.
Why?
I take the big.
Can you tell her why you did it?
Well, I was kind of desperate in need of something over my head. I apologize. I'm not good at apologizing. I'm sorry.
Okay. Anything else you want to say?
No.
All right, so Mr. Johnson, you're 23, you have no record. And you just see this lady get out of her car, go in her house, and then you just want to take her car? Like, what made you do that? You were what? It was a troubling time. And how is taking her car going to help you not to have troubling times?
It was going to add to what I didn't have.
Hmm?
It was going to add to something I didn't have. I was thinking fast, but
Well, there's something all of us may want, something all of us may not have, but we just don't go take it from other people. That's her car. That's not gonna bring you any joy to take something from somebody else. So, where do you live?
in college too right now.
With who? With your mom? Is she here? Where is she?
She's at home.
At home? And she knew you had to come to court today? And then I could put you in jail?
She got babies to raise.
Oh, she has little babies?
Yes.
Are they your sisters and brothers?
Yes.
I see. And, is she just not want to deal with your foolishness?
Yeah, kind of.
Mm-hmm. So she said, you want to be a big boy, take people's cars, then you go down to court by yourself. Is that kind of what she said? Mm-hmm. So, why should I put you in prison?
Because I'm sincerely sorry.
You sincerely sorry? That's like robbing a bank and saying, oh, you know what, don't put me in jail because I'm sorry. So that's not a good reason. Tell me another reason.
I'm really trying to get my life back on the right path.
How are you doing that?
Staying focused, staying on the future way and everything. And I'm trying to get a job and everything at the moment. But I think the interview is scaring people off.
Okay. So you put application in where?
Everywhere really. McDonald's, everywhere I'm going from Wendy's. It was an Amazon warehouse factory.
So how do people know you're on EMU?
Like I showed up for interviews. I had showed up for interviews.
Showing your EMU?
No, it's kind of like they asked, and I wasn't. The first part of it, I didn't know that. I wasn't considered a felon or anything at the moment because I was going through the process, and I was writing that down on the paper, and they were saying like, yeah, we don't hire felons.
Oh, so you were putting that you were a felon on the paper? I see. All right.
It's just something.
Why don't you take your medicine?
I just haven't, been able to go back to Kroger's and get a refill.
Is it free?
Yeah, yes, ma'am. Yes, ma'am, it's free.
So you have time to put in applications for jobs. You have time to go steal this used car, but you don't have time to go get your medicine? You see how that sounds? Make time. Okay. So the court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, and I've reasonably calculated this sentence to achieve the two overriding purposes and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on society, but also on Ms. Jennifer Hughes, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Johnson, because this is a felony of the 5th degree, community control is a presumption, I'm going to place you on 18 months community control, intensive supervision. You're going to submit to drug and alcohol testing. I'm going to order that you take your prescribed medication. You understand? Because if you went to the doctor because something was not feeling right, and the doctor told you what to take so that you could feel right, why would you take it? Okay, so you're going to be ordered to take that. Court costs and fines are remitted. Ms. Hughes, no restitution? Is there any way to pay you back? The car damage anyway? Steal anything out the car? Okay. All right, no restitution ordered. Oh, I'm also gonna order you find and maintain employment. Okay, keep you busy. And if you violate the terms of community control, I won't hesitate to sentence you to a term of 12 months in the Ohio Department of Corrections. Do you understand? All right. We're also going to give you a card or some information. There is a office right across the street called Office of Reentry. They can help you with finding a job. Because now that you've been convicted, now you really are a felon. You understand? But there are lots of people that will still hire you because second chances, right? And you deserve a second chance. And so the Office of Reentry will help you find that job. I want you to find that job. So we'll send you over there and you tell them Judge Cross sent you. All right? And they'll help you find a job. Anything else, Ms. Alexander? State?
And will the court also be imposing a stay-away order from Ms. Hughes?
Yes. Now, you know where you went to take her car, right? You gotta stay away. Where was that?
I'm sorry, Your Honor?
Where was it? Which street? Was it in front of your home? What street? You gotta stay away. You don't live over there, do you? Yeah, so stay away from there. You ordered to stay away from there. You understand? And stay away from Ms. Hughes. So I know you didn't know who she was, but just for example, say you just happen to go to a McDonald's and there's Ms. Hughes. You have to leave. You understand? Okay. All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? All right, I wish you well. So, Ms. Howardson, Ms. Mays gave, there's information for officer reentry. You go over there after probation and you tell them Judge Cross sent you, and they'll help you try to find a job. All right.
Thank you.
Oh, I'm gonna terminate the interview.
Thank you.
Thank you. Thank you, Ms. Hughes. I'm sorry that this happened to you. All right. What do we have next?
Judge, I was hoping you could call Samuel Harris.
Yes, sure. This is the matter of State of Ohio versus Samuel Harris, case number B24025575. Mr. Harris is present in the courtroom, his attorney, Ms. Brittany Ellis, and Mr. Christopher Sawyer, present in the State of Ohio. Let me just give Mr. Sawyer just a moment. All right, Mr. Christopher Sawyer for the State of Ohio. This matter is on for jury trial today, and, counsel, are you ready for trial?
We are.
All right, State?
The United States is unable to proceed with trial, and the prosecuting witness is not present today. I have made multiple attempts to call her on her phone. I have left her 2 voicemails on this recording this past Friday. She has not responded. As well, Your Honor, and I'll be here to report. Brandon Brown previously spoke with her back in September. She did not wish to go forward, although she did deny what happened either. With that being said, the county would respectfully request the continuance to attempt to get personal service on Ms. Harris. Additionally, none of the officers from Corey Township were present.
All right, thank you very much. Ms. Ellis?
Judge, we would ask for dismissal based on everything you've heard so far. I'm in agreement with everything that was said. I know that the prosecuting witness was here at a plea or trial setting back in September, I want to say. The prosecutor at the time, Mr. Brown, did indicate to me that he spoke with her. She did not wish to go forward with the charges. Since then, Your Honor, it sounds like she's aware of this court date. I think on that court date, we went over the final pre-trial and the jury trial date. She's not present today. Your Honor, Mr. Harris has been at all these court dates. He has been on juris this entire time, no violations to my knowledge. We are ready to go today, so we would ask the court to dismiss based on everything heard.
All right. It appears the state has done everything, first of all, its due diligence and gone above and beyond. And its due diligence to contact the victim here, the alleged victim, and with no cooperation of the victim. Mr. Harris, let me give you, this is the second one today, a word of advice. I'm going to dismiss this case, and you are presumed innocent, but I don't like these charges. Strangulation, domestic violence. You should know that. If you come back into this court with any charge of violence, it will not be good for you. Do you understand? Well, I won't be worried about it. You would have to worry about it. Do you understand? So you are presumed innocent. The law says that you are innocent as you stand here. I wasn't there. I don't know what happened. But When I see charges of strangulation and domestic violence, please heed my word of advice, and I'm only giving it to you once. Do you understand? The matter will be dismissed for warrant of prosecution. EMD is terminated. Mr. Evans,
Yes, Judge.
you ready to go forward or discuss your case?
I'm ready to discuss, but I am ready to go forward, but we also would like to potentially discuss. emergency.
All right. Well, let's do that. Let's go, James.
I'll tell you, you know, reason.
All right. This is a matter of State of Ohio versus Destiny Benson. Ms. Dunson is present in the courtroom with her attorney, with Ms. Brittany Ellis, who is actually covering for Ms. Sharonda Hunter, and Mr. Christopher Sawyer for the state of Ohio. This is case E2402750. Today we set for jury trial, but my understanding is that the parties have resolved this matter by way of an agreement, and I've been handed plea documents. Is this how you plan to proceed today?
She does, Your Honor.
All right, and Ms. Dunson, are you okay with Ms. Ellis representing you today in the absence of Ms. Sharonda Hunter? All right. Are you the Destiny Dunson named in this indictment? All right, I need you to get to the microphone so I can hear you better. All right, thank you. Ms. Dunson, how old are you? And how far did you go in school? So you're able to read and write the English language well? Are you a U.S. citizen? And have you ever served in the military? All right, now you just speak as loud as you can, okay? All right, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Ellis' signature here. And is this your signature right above?
Yes.
This is an acknowledgement by you that you understand that you have a constitutional right to the trial. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving my right to a trial. I don't want to have a trial today. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with your attorney about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to the trial? I also have in my hand a 3-page document. And it's entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Mr. Sawyer's signature here and his bar number, Ms. Ellis' signature there. And then right up here, ma'am, is this your signature where it says signature of defendant? All right. Mr. Prosecutor, can you please put on the record the party's expectation regarding this plea of guilty?
Your Honor, his expectation of the court's permission that the defendant be entering a plea of guilty as charged to 1 count of theft and misdemeanor for second felony of the 5th degree in violation of the revised code section 2913.02.
All right, thank you very much. Ms. Ellis, is that accurate?
Yes, Your Honor.
All right, Ms. Dunson, is that your understanding too? All right. Are you under the influence, ma'am, of any medications, any alcohol or drugs today? Do you now or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty today? Are you making this plea of your own free will? The state has indicated that it's expected that you will enter a guilty plea as charged to the single count charge in the indictment, theft, a felony of the 5th degree. Is that what you talked with Ms. Ellis about before this hearing today? And did you have an opportunity, ma'am, to review this 3-page plea form with Ms. Ellis before this hearing? Do you have any questions about it? Did Ms. Ellis answer all of your questions about it? Ma'am, do you believe you had enough time to sufficiently consult with Ms. Ellis about your entire case before this hearing today? Well, I guess I should say Ms. Ellis and Ms. Hunter. All right. And have your lawyers answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the evidence that the state has against you with Ms. Ellis and or Ms. Hunter? All right. Mr. Prosecutor, can you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
And the state has provided the defense with all discovery as well as all Brady material, if any, to the defense.
Ms. Ellis, do you acknowledge receipt of same?
Yes, it appeared that way, Your Honor.
All right, thank you. Ms. Benson, are you satisfied with your two attorneys, Ms. Hunter and Ms. Ellis? Now, do you understand this charge against you, theft, a felony of the fifth degree? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being a felony of the fifth degree, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500? Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? And if I sentence you to prison and you are released from prison on post-release control and you violate the conditions of post-release control, do you understand that you could be returned to the institution for a total of up to 1/2 of your original sentence? Are you on post-release control right now? Well, if you are on post-release control and you commit a new felony offense while on post-release control, do you understand that the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater? Do you understand that? All right, do you have any questions? Now, since this is a felony of the fifth degree, community control or probation is a possibility. Do you understand that I can place you on probation or community control for up to 5 years instead of sending you to prison? Do you understand that if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties, but the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. Do you understand? Also, do you understand that if I place you on community control, that you would have to comply with all the terms and conditions of community control established by this court? Also, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand? Do you have any questions? Ms. Dunson, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to a court or to a jury of 12 persons? Do you understand you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them to you? Do you have any questions about your constitutional rights? No. Do you have any questions about anything we discussed? Do you understand that when you plead guilty, you are waiving all of these important constitutional rights? All right. Ma'am, knowing everything the court has discussed with you today, do you still wish to enter a guilty plea as charged to the theft charge, felony with fifth degree? Counsel, is there anything further required except the plea?
No, Your Honor.
May I hear a statement of facts?
Honor, about June 10th, 2024, in the United States of Ohio, Destiny Johnson, with the purpose to deprive the owner of certain property or services worth $1,000 or more, but less than $7,500 to retail merchandise belonging to Walmart, knowingly obtained or exerted control over such property or services without the consent of the owner or person authorized to give consent. Theft, felony with fifth degree, violation of revised code section 2913.028.
Anything on the Pikes Council?
No, no.
Ms. Dunson, do you hear what the prosecutor said you did? Is it true? What is your plea to the single count in the indictment, theft of felony in the 5th degree? Let the record reflect that Ms. Destiny Dunson was present in court with her attorney, Ms. Brittany Ellis, who was actually covering for Ms. Hunter, and that Ms. Dunson was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Dunson understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ms. Destiny Dunson guilty as charged to count 1, theft of felony in the 5th degree, in violation of Revised Code 2913.02, subsection A1. Counsel, is there any reason why a sentence should not be issued today?
No, Your Honor.
All right, are you waiving the PSI?
We are.
Well, there's a victim impact statement that needs to be had to comply with Marcy's law. The state, have anything to say about that?
Your Honor, county would be asking for a victim impact statement. However, looking at the file here, it looks like Mr. Brown spoke to Walmart back in September, and at that time, there was no restitution, but they were not open to any sort of redemption.
I see, all right. Do you believe that Marcy's law has been complied with?
As far as the victim's impact statement goes, I do not believe so, Your Honor. They do have the right to be present, be heard at the sentencing.
Okay, all right, well, then that's what we'll do. We will continue this for sentencing. Ms.
Judge, if I may, I thought Walmart was here. I'm sorry, I must have misunderstood. I thought they were.
Is Walmart here? Oh, Walmart's here.
I was
Thank
thinking,
you.
we could go ahead and do it today.
All right, well, then let's, ma'am, you want to step up? Ma'am, what's your name?
Carla Williams.
All right, Ms. Williams, you represent, loss prevention?
Yes.
For Walmart. Thank you very much for being here. All right, what would you like to say on behalf of, Ms. Dunson?
Thank you, Judge. On behalf of Ms. Dunson, we are going to be asking the court to consider a term of community control, Your Honor. I think the goal of this case was to try and get a reduction to a misdemeanor, but ultimately the state and the parties, they were not willing to do that. This is her first ever felony, and hopefully her last, Your Honor. This is a significant consequence at 23 years old to have a felony on her record. She is a mother, Your Honor, to a 1-year-old son and a 1-month-old daughter. So she was pregnant while this case was going on and just had her daughter. She's trying to obtain child support right now and she has to receive that. Your Honor, she does work for a temp agency. I know she's looking for more stable employment. That's what she's doing right now to make an income. Her parents are here, both her mother and father. I spoke to them in the hallway. Oh, there we go. Okay. They were here, Your Honor. I did speak with them about the plea and the consequences that their daughter would be facing. I know they lectured her very sternly about what she had done and that this was a very stupid mistake. But they did tell me they supported her and just wanted her to learn from this and do better in the future. So that being said, we are asking you to consider, again, a term of community control. I would suggest 1 year. I don't think my client will have any issues on your community control.
All right, thank you very much. State?
Your Honor, county is ultimately going to defer to the court for sentencing. However, I would like to note that last year, the defendant was convicted of unauthorized use of property for using a stolen EBT card at Speedway.
Sorry, a stolen what?
EBT card at Speedway, and ultimately her probation was terminated May 10th of this year. She then subsequently goes out, impersonates a store employee at Walmart, and steals thousands of dollars in merchandise from Walmart.
Okay. Thank you. And there's no restitution? Everything was recovered? Okay. Young lady, is there anything you'd like to say before I pass sentence? Well, tell me what you did, because I'm intrigued now. What'd you do? No, let's talk about UDF. Why we're here. What did you do?
I went into the store and I bought some things.
I'm sorry, I can't hear you. Can you-
I went into the store and I walked out with pots and pans and I went back in to grab more. And that's when I got caught.
Okay, so how did you, impersonate an employee of Walmart?
It was a Walmart vest I was found.
I'm sorry?
It was a Walmart vest I found.
A vest?
Yes.
Oh, so you found a Walmart vest and then you put the Walmart vest on and then you walk back in, you walk into the store like you're an employee, so nobody really asked you anything? And then you took some pots and pans and you walked out
Yes.
with the vest on?
Yes.
And that's when they stopped you?
Mm-hmm.
I see. And you actually got out the store, but you went back in to get more?
Yes.
Okay. And when did you think this was a good idea?
It was a stupid mistake. I'm not sure.
Well, literally, I'm really curious to know. When did you think, I got this Walmart vest, I'm gonna go in there and take their stuff, and they're gonna think I'm an employee? Because you had to be thinking about it, right? How soon after you had the vest, did you find the vest that you actually went to the Walmart?
I was going to the Walmart and I found it inside the cart.
Oh, inside the cart, outside Walmart? I see, in the parking lot? Okay. So did you go to any other Walmarts?
No.
Okay, just, you found it outside, and you, what did you go to Walmart to get?
I was going to get
Some
some baby items.
baby items. But then when you got the vest, you said, oh, well, I'm gonna give you some pots and pans too. And between the time you found the vest in the parking lot, you put it on and went straight in there? Did you call anybody and say, hey, I just found this, this is what I'm getting ready to do?
No, I didn't go straight in there. I thought about it and I put it on in there.
You actually thought about it. So you planned. After you got it, you thought about it and then you went into the store. Now that I'm saying it back to you, how dumb does it sound? Mm-hmm. Okay. So, you have 2 children?
Yes.
And you're working to try to support those children?
Yes.
Well, you can't do that from jail.
No.
And this is your second time in the theft offense?
Yes. The first one I
The first one what?
The first one didn't have nothing to do with me.
Did you use the EBT card?
Yes, but I thought it was mine, like I was co-worker when I put my coat in and one gave it to me, they thought I dropped mine when I went to the store.
Does the EBT card have your name on it?
Yes, and I swiped it and I put my code, I didn't let the name, I swiped it and I put my code in and it went through. I have my own percent, so I wasn't.
Well, how'd you get it?
Like I said, someone, when I went back to the car to get my wallet, he thought I dropped mine, so I put it in the wallet and I went into the store.
Oh.
And it's my child's father, the other baby mom, so I know that,
Whose EBT card was it?
it was my child, my kid's, sibling mom.
Oh, I see. How are we gonna get you to make better decisions?
This is about a lot.
What has it taught you?
Don't do dumb stuff.
Don't do dumb stuff? Well, then you know that before you did the dumb stuff?
Yes, I was just going through the time, just like, I went in there just got study, that's what I was going there for.
Mm-hmm. And when you decided to put this vest on and go back into Walmart, did it ever cross your mind, like, I'm going to jail?
No.
Really? Especially when you got out the first time and then you decided to go back in. It didn't cross your mind then when you was like, oh, I got away with it. I'll go back and do it again. It didn't cross your mind like, I got away with it. I'm pretty lucky lucky, but I'm really going to jail if I go back in the store. No?
Time, no, but when I was going and leaving, yes.
What'd your parents say?
It's still good.
Mhm. Did you call your baby's father when you found the vest?
No.
Was anybody with you?
No.
Do you have anybody that you can call to bounce off ideas and decisions that you make before you do them?
Yes, I do.
Who?
My parents.
Okay. So, when you found the vest, as you were planning, before you went in, how come you didn't call your parents?
They were gonna talk about
Because they were gonna talk you out of it. Exactly. So you want me to feel sorry for you now?
No.
Because what you're telling me is, I have a support system. That if I decide I kind of want to do something dumb, I have a support system that will talk me out of it. But I'm just not gonna listen to it. I'm not gonna talk to them. That's what they're there for. Do you understand? You gotta use them. So they can talk you out of dumb stuff. All right. Does Walmart have a, do you want to see anything happen?
Just to stay away.
Stay away.
Yes, ma'am.
All Walmarts? Which Walmart was this? Even there? Okay. I hope you didn't really like Walmart, because you're gonna stay away from all of them now. You understand? I mean, I like Walmart. Everybody likes Walmart. But you can't go there now. You understand that? Okay. Well, stay away. Make sure that you says from all Walmarts. That way, Ms. Dunson is real clear. All Walmart stores. So if you think you want to go to a Walmart, which is be something dumb, you need to call your parents. The court has considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've recently calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on society, but also on Walmart stores. And to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in Revised Code 2929.12. Accordingly, Ms. Dunson, I hereby sentence you to a term of 12 months community control. Stay away from all Walmart stores. Costs and fines are remitted. Let me tell you something, no restitution, zero restitution is possible. If you violate the terms, if you go to Walmart, you go, oh, that judge, she's not gonna know. They're gonna know. You understand? And then I'm gonna know. If you violate the terms of community control for the next 12 months, if you come back here with any type of theft, I don't care if you stole a nickel from a little girl, any type of theft, take anything that doesn't belong to you, it's a violation, you understand? And I will not hesitate. I will feel bad for your babies, but I won't hesitate to send you to the Ohio Department of Corrections for 12 months. Do you understand? All right, we clear? All right. You'll need to go to probation right after court. They'll sign you up, and it won't take very long. Now, does she have PAU or anything? Okay. All right. Excellent. All right. Anything else from the state?
No, you're
All right, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, ma'am, then an attorney will be appointed to help you at no cost to you. Do you understand that? All right, I want you to think. Think about what you're doing and think about those babies. You understand? All right. I wish you luck. Thank you. I don't have cross findings. Since wrong findings. Yes, they can go. Price. Where's Mr. The rainbow over now? Okay, good. Mr. Cook? He refuses. Okay, well, that's all right. We're going to say, let's see.
Want to talk, Ms. Ellis? Who's doing Ms. Ellis?
What was that again?
So this is his certificate from Judge Britton asked me to go talk to Mr. Frank.
Yeah.
He's going to leave today. I would need to go off with a few points off. I didn't know if that was within the realm of possibility for what the rest of your docket.
Yeah.
Gives a reason.
Yeah, I would really appreciate if we could continue with what we do. If that's okay.
Yes.
I told him there's a distinct possibility, but just where things
Appreciate it. I appreciate it. So, if you can get a date for it, is it already supposed to set for a plea?
That's right.
I think so. It's just, everyone's here today as far as the victim. I just didn't know what one to go ahead and hear from the victim today while they're all present. But I understand clients not down there, so.
So I think about all this. Because I always find that you should ask for them, and I should say, I spoke to both of you.
They want to just say they're sent to, if people, I think they're going to say that they will be expressing the truth. They're not prejudice, so whatever.
They're saying this.
See, they want to produce. Yeah, but Ms. Howard, what's the date on price? It was set the trial date.
Yeah.
Monday, December 2nd.
Whatever y'all say is fine. I'm gonna be out on next week, it's fine. Got it.
Is there, there's nothing to do this week, honestly. I just, he's locked up. I know we don't have time to do it. That's all.
We could possibly do it on Wednesday.
I'm in here Wednesday, I'm on a case, so, that one I'll do is my James Evans. So I can handle it if Sean is still out.
Is that motion to press along, Wednesday?
No, Your Honor.
Is that your case?
Yes,
Oh, okay.
I filed a motion to continue. He's incarcerated in another county.
Oh, okay. Looking, yeah.
That being said, Your Honor, you had all 5 witnesses.
Yeah, there's a motion to continue.
I haven't seen that.
Oh, yeah, I see it.
What if Miss Ellison?
Yeah,
She let me know it was going to be 5.
okay, yeah, you can claim this. Wednesday?
We could set it Wednesday at 9:30.
Yes, that would be great, thank you. Thank you.
Time wave until then?
Yes, Your Honor, thank you.
All right. Where's Mr. Evans?
I'm not sure, Your Honor, so he's done.
Okay.
So he and Mr. Lewis don't call
Let's see. Mr. Evans,
Yes,
you
Judge.
ready?
Are we trying to start on the motions? I'm comfortable doing at least everything except the motion to dismiss without my line. Everything we discussed. If you want to kind of get started.
Yeah, so, let me come. This is a matter of State of Ohio versus Robbie Cook, case number B24038182. Mr. Joshua Evans for Mr. Cook, Mr. Christopher Sawyer for the State of Ohio. This matter is set for a jury trial today. Mr. Cook is actually on his way being brought to the courtroom. It was my understanding from information we received from the jail that he refused to come over.
That's news to me as well. Your court staff let that be known to me, and I judge that.
Okay.
I didn't know.
All right, well, he's being brought over here now, and so, we've had a off-the-record discussion, pre-trial, just to see where the parties were, and I guess, have you had a chance to talk to them? Since we had our conversation?
You mean just previously today, Judge? No, I haven't. He's not here. It's
Okay. So you don't know what he wants to do?
Well, I know that he wants to proceed with trial from prior conversations, but He told me I could authorize to agree upon this behalf. Granted, depending on how emotions turn out that we have.
Okay, but we also talked about some new information that you received. Have you ever had a chance to talk to him about that and determine whether or not that has changed his mind?
I haven't, Judge. When he gets here, I will discuss that with him.
Okay.
After our conversations, you ordered him down, and I was just gonna talk to him when I had a chance.
Okay, all right, so, stay ready to proceed? All right, so there's a motion to dismiss, there is a pretrial motion, 404B evidence, and then there is a discovery issue, that you received discovery late?
Correct.
All right, so let's just talk about the two things, and then we're gonna wait until he gets here. He's not coming. He's not coming.
Sergeant said that he refused to come out, so they really strapping with the chair.
All right. Okay. What we're gonna do is we're gonna take a recess until 1:30. And you're gonna go over to the jail and talk to your client, because when they went to get him, he's refusing to come over. Now, I have the authority to make sure he gets here, but I'd like for you to go talk to him first about all of the pretrial issues, and then we will reconvene at 1:30. And I want to do that, because we've had, officers and witnesses here since 9 o'clock. So, 1:30, okay? We'll be in recess till then.
Judge, if we work this lead, I'm okay with him releasing his witnesses. I don't think we can get 24 here today. If the court sees fit.
Let us deal with that.
Yeah.
You just have one goal right now. Talk to your client. All right, we're in recess. Judge Newberg. No, we're done. Till 1:30. It's warm in here. It is warm. It's warm. Come on in. Wow, you got a lot going on.
I'm gonna turn this on. We shut all the way down.
Yes. Oh, that was so cute, I just laughed. She get the girl. Oh, sure.
What am I, Rosetta Stone?
We have reason to believe she's a prostitute. Any of your girls, maybe from 15 years back, speak Portuguese?
She